Hello, good morning, everybody, or good afternoon if you're on the East Coast. Thank you for joining the National Immigration Law Center's webinar to talk about the ending of DACA. I know all of us were extremely frustrated and heartbroken to hear the announcement on Tuesday that the administration is carrying out its anti-immigrant, xenophobic, and racist agenda by ending this program, which has been extremely successful. So we know people have a lot of questions about what this means, especially if you have DACA yourself. Also, a lot of questions about what this might mean for your employment and your healthcare benefits. So we have several guest presenters from NILC who are going to talk about all these issues. And we're also going to give you a lot of concrete steps that you can take to show your support for DACA and to really push Congress to protect immigrant youth. So I'm going to turn it over first to my colleague, Ignacia Rodriguez, who's going to talk about this unfortunate end of the DACA program, the prospects that we see in Congress for legislation to protect undocumented youth, and a little bit also about what this means for education.
Thank you, Shimeng. So I'm going to go over what happened on September 5th and what are their implications both for the DACA program and also for eligibility for advanced parole. So on September 5th, the Trump administration, in a very inflammatory manner, announced the rescission of the DACA 2012 memo. So what does that mean for individuals who are eligible for DACA? Well, individuals who do not have DACA today will not be able to obtain it in the future unless their applications are currently pending with USCIS. So if the person applied for DACA for the first time and is waiting to hear back from USCIS, then that application will be processed so long as it was accepted on September 5th. But if the person never submitted that application, unfortunately, they can no longer submit it. The next question is also, what does this mean for individuals who have or had DACA? So individuals who have DACA today will be able to retain their DACA in work permits until their expiration. Some people think that March 5th is a cutoff for those permits, but the administration has stated that they will be held valid until they expire on their own. Individuals who have DACA today will not be able to renew their DACA or work permits, except in two situations. One, individuals with currently pending renewal applications. So if the person applied for DACA renewal by September 5th and is waiting to hear back from USCIS, that application will be processed as normal. The second exception is individuals whose work permits expire between September 5th and March 5th. These individuals can apply for a renewal so long as they apply by October 5th. So if your work permit expires after March 6th, so March 6th or later, you will not be able to apply for renewal. If your work permit already expired by the 5th, you will not be able to apply for renewal. And then lastly, the DACA rescission had implications for the advanced parole program. As a reminder, that's the program that allows a person with DACA to be able to travel abroad for humanitarian, employment, or educational reasons. USCIS announced that they will no longer approve advanced parole applications associated with DACA, but if you have a pending application, they will go ahead and return your money, but they will not be processing or approving that application. If, let's say, you applied for advanced parole and you were granted advanced parole already, they said that they would respect that grant, but we do encourage people to take extra precaution if they do choose to use advanced parole to leave the country. So ideally, have handy the Department of Homeland Security materials stating what the announcement is. Also have with you the number of your attorney or BIA accredited representative. Have them on call when you return to the United States. And that's because you may interact with customs officers that may be confused by the announcement and presume that DACA has ended completely, or you may interact with boldened agents that may take this opportunity to give you a hard time before allowing you back in. So now that I've gone over what the announcement entails, I'm going to discuss at least one legislation that's on the table, and that's the DREAM Act. So the DREAM Act was introduced on July 20th by Senators Graham and Durbin, and then another bill was also introduced in the House. The DREAM Act does provide a path to citizenship, which is why people are pushing forward the DREAM Act rather than the Bridge Act. The Bridge Act, if you recall, would only extend the benefits that DACA provides 3 years after enactment. So it's time limited, and it does not provide a path to citizenship. But the DREAM Act does, and here is a projected timeline of how long it would take. So it could take 13 years, it could take less depending on when you fulfill the requirements. And then the requirements are listed here, which for the sake of time, because we have a lot of good information, I won't go over. But if you notice, some people who are eligible for DACA never had a chance to apply. They could be eligible for the DREAM Act. Also, people who were never eligible for DACA could be eligible. So for example, people have to have entered before turning 18, rather than for DACA, people had to arrive before the age of 16. So those are just some examples of how this could be a good thing, right? Could help more people than those who have DACA or were ineligible for it before. And then the requirements continue because it's a two-step process. First, you have to become a conditional permanent resident, and then you become a lawful permanent resident. We do have materials on our website at NILC.org that go over this in more detail. We have a frequently asked question on the DREAM Act. People have asked, though, what is the chances of the DREAM Act passing? Well, there's a lot of momentum right now. There's a lot of progressive groups that are pushing forward for legislation to pass, for some relief to be provided to these communities, and so we just have to continue providing that pressure and putting that pressure forward in hopes that something like this could be passed as soon as possible, given the uncertainty that our communities are experiencing. So we encourage you to join our fight, and also to check out weareheretostay.org for more information on how you can push members of Congress to move the legislation forward. And lastly, I'm going to talk briefly about how does the DACA rescission affect your educational opportunities. So this is really specific to the individual. You have to really pay attention to where the individual lives, where they go to school, because honestly, like the way that DACA rescission affects your ability to stay in school and to pay for school varies state to state, school by school. So on our website, we do have a comprehensive frequently asked questions document that goes over this with more specificity. It's also on the weareheretostay.org website. But as a roadmap to you all that are thinking through this, there's 3 things you want to think about. So how does DACA ending affect my ability to stay in school, to be able to continue being enrolled, right? Certain states provide admission based on having DACA, don't allow people who are undocumented to be enrolled. Second, how does it affect my ability to get in-state tuition? Some laws, for example, in California that provide in-state tuition to DACA recipients to say that it's regardless of immigration status, so long as you meet a certain set of requirements. But if it's a in-state tuition policy that's specific to DACA, then that may no longer be an option for you if your DACA ends. And then third, how does it affect your ability to get financial aid and scholarships? So try to think through what it is that you presented to the school or to the scholarship funders in order to receive that grant. Did you show your work permit? Did you have to provide a social security number? And then also have a conversation with your school, with the financial aid office, to get a clear understanding of how this would affect your ability to pay for school. But again, there's more detailed information, state-specific information available on our website, so you can check that out.
Thank you, Ignacia. So that was a lot of information. So if any of you have questions please continue to write them in the chat box. We're going to have two sections where we take your questions, so you'll have plenty of time to enter them into the chat box. And next, I'm going to turn it over to Gabrielle Lessard to talk about access to healthcare and how this is affected by the ending of DACA.
Hi, everybody. As you may know, DACA recipients are not eligible for federally supported Medicaid or CHIP and are the only class of lawfully present immigrants who are excluded from eligibility for the Affordable Care Act. So most of the changes in access to health care are actually going to be in the arena of employer-sponsored insurance. A survey of DACA recipients showed that over 50% of DACA recipients got a job that provided health care or other benefits as a result of getting DACA. So that employer-sponsored insurance should remain in effect as long as the person remains employed. And my colleague Josh Stalick will talk about employment in the next section. When a person's employment ends, they'll receive a notice saying that they can continue their insurance through COBRA. And some people might want to do this, particularly if they're in the course of receiving treatment. However, COBRA can be very expensive because the person receiving COBRA has to pay both the employee and the employee's contribution toward the cost of the insurance. So if this happens to you, you should compare COBRA to other health insurance options that are available, working with an insurance broker, or if you have a health plan you like, with your health plan. By losing employer-sponsored coverage, you will have what's called a special enrollment period under the Affordable Care Act. And even though DACA recipients are excluded from the Affordable Care Act, the insurance companies are only permitted to sell insurance during either open enrollment or an individual special enrollment period. So that special enrollment period will last for 60 days after the person loses coverage. They can also purchase coverage during open enrollment. In most states, open enrollment is November 1st to December 15th, a very short window this year. California has asked the federal government to extend its open enrollment to January 31st. And if you are receiving coverage through your family member's job, there's no immigration status requirement connected to that, so the termination of DACA will not affect your ability to get that kind of coverage. Sorry, I'm having trouble advancing the slides here. Okay. Yes, I am a Mac idiot. Okay, so there are some state and local programs that provide coverage to DACA recipients. Washington, D.C. provides health care for all low-income residents of the district. So for those people, losing DACA will not affect their eligibility for that program. California, Massachusetts, Minnesota, and New York provide coverage for low-income DACA recipients, in some cases through their Medicaid program, which is called Medi-Cal in California. And then in Washington State, DACA grantees with disabilities might be eligible for medical coverage. We believe that former DACA recipients can remain eligible for these programs. However, advocacy might be required. So people should connect with a state-based advocacy organization to see how they can get involved in advocating for that continuation of coverage. And then there are some cities and counties that cover residents regardless of their immigration status. So for example, here in Los Angeles County, we have a program called My Health LA. And losing DACA will not affect people's eligibility for those local programs that are available regardless of status. If you are pregnant, there's more access to care related to pregnancy. So many states, and the slide will link you to a map, and Washington, D.C. provide coverage for pregnancy-related services through their children's health insurance program, regardless of the woman's immigration status. In other states, low-income pregnant women are eligible to receive labor and delivery services through their state Medicaid program. And then if you are under age 19, there are a number of states, California, Illinois, Massachusetts, New York, Oregon, and Washington, that provide full scope health coverage to all residents who are under age 19, as long as they meet the income eligibility requirements for their state Medicaid or CHIP program. And again, Washington, D.C. provides health services to all income qualified residents. And then there are a number of programs that are open to everyone, regardless of their immigration status. So those services will still be available. Anyone who has an emergent medical condition can go to an emergency room and at least receive stabilization, have their condition stabilized, without having to respond to any questions about their insurance status or immigration status. Community health centers and free clinics are open to everyone regardless of status. Public and safety net hospitals have a mission to provide care, and people can receive services there. There are public health services like immunization, treatment of communicable disease. Those services are available to all members of the community regardless of status. And then if you're eligible for Medicaid in your state, except you don't have a qualifying immigration status, you can receive emergency treatment under emergency Medicaid, and that includes labor and delivery for pregnancy. There are also hospital financial assistance programs. Nonprofit hospitals are required to make information about these programs available to their patients, and then there are charitable programs. So an example of a large charitable program is one operated by Kaiser Permanente, which has programs that offer free or reduced price enrollment in its plans within its service area. And that is all I have. I'm going to turn it over to Josh.
Thanks, everybody, and thanks, Gabrielle. I'm going to talk now a little bit about DACA and employment issues, and particularly some of the employment-related issues that could arise from Tuesday's announcement. I do want to stress at the outset, though, that based on the announcement, your current DACA and work authorization or work permit expiration date remain valid. So you remain work authorized at least through your current expiration date, and potentially longer if you qualify for and receive a renewal under the terms of the announcement that Ignacia talked about earlier. So one of the big questions that is coming up is whether your employer can now ask to see your work permit again. In employment law terms, this is called re-verification, and the short answer to that question is no. Once you're hired and complete the I-9 employment eligibility verification process or the E-Verify process, if it's an E-Verify employer, your employer should not ask to see your work permit again until the expiration date. And in some instances, it would be unlawful discrimination for the employer to selectively re-verify employees on the basis of your national origin, your ethnicity, or your citizenship. So if your employer, in the wake of the announcement, starts to re-verify only Latino employees, for example, that would likely be unlawful discrimination. If your employer is asking to re-verify your work permit, you can call the Immigrant and Employee Rights section of the Department of Justice at their toll-free number, which I've listed there. This is the department of or division of the Department of Justice that used to be called OSC, or the Office for Special Counsel of Immigration-Related Unfair Employment Practices. It's the division of the Department of Justice that enforces the anti-discrimination provisions of immigration law. And I did want to note that just yesterday, the California Labor and Workforce Development Agency, which is a California state agency, circulated a notice to employers that confirms that employers should not be re-verifying the work authorization of current employees based on the DACA announcement. So even if you're outside of California, that might be a helpful document which we can link to in the follow-up email to this webinar, because it does lay out the current law and explains to employers that they shouldn't be re-verifying workers. Now, looking ahead, as I know many folks at DACA are, the cases in which your DACA and work permit are expiring, I mean, again, that shouldn't be happening until March 5th, 2018 at the earliest, assuming that people who have expiration dates prior to that do apply for renewal and receive renewal or at least apply for it, and that application is received by USCIS by October 5th of 2017. And I did also want to underscore that we are very hopeful and are definitely advocating for a legislative fix. And as Ignacia talked about, we and many other organizations are advocating with Congress to pass the DREAM Act. So hopefully we will see some legislative solution prior to March 5th, 2018. But of course, that does remain to be seen. So looking forward to potentially a scenario in which your DACA and work permit have expired, the question then comes up, should I tell my employer that my work permit has expired? And no, you do not have an affirmative obligation to tell your employer that you have DACA or that your work permit has expired. Under the law, it's the employer's obligation to track its employees' work authorization, using the I-9 employment verification process, and it's the employer's obligation then to ask to see your new work permit when your current work permit expires. It is true, though, that if you continue working after your work permit expires, you'll be working without authorization, and your employer may, if and when it realizes your work authorization has expired, then terminate your employment on that basis at any time. We've also received some questions about what happens to your Social Security number that you obtained once you received DACA. And your Social Security number remains yours for life, even if you no longer have DACA or legal authorization to work. So you should continue to use your Social Security number to file any required income tax returns. And you can also potentially then continue to use your Social Security number for things like banking purposes, for educational purposes, and to obtain housing in some instances. But your Social Security number will not be valid for work purposes without a valid work permit. So if you lose DACA, but you do receive work authorization in the future, perhaps on the basis of a legislatively passed DREAM Act, for example, you'll then be able to go back to using your Social Security number for employment as long as you have valid work authorization. And then another big question that has come up is whether or not, if you lose work authorization, you can then work as an independent contractor. And that's differentiated from work as an employee. And under federal law, businesses are not required to check whether an independent contractor with which the business has contracted for services has work authorization. But a business is prohibited under federal law for contracting with an independent contractor that the business knows lacks authorization to work. So an employer does not have to affirmatively check that an independent contractor that it is contracting with for services has work authorization, but it will be liable if it contracts with someone that it knows lacks work authorization. And then I've included some resources on the next slide that are specific to DACA and employment. And the middle resource, immigrantsrising.org, also includes resources on immigrant entrepreneurship or working as an independent contractor and or starting your own business.
Great, thank you. So we're going to take a couple of questions right now. And the first one, which has come in from at least 3 people, is what does the term accepted mean? So Ignacio, you talked about initial applications having to be accepted by September 5th and renewal applications have to be accepted by October 5th. So what does accepted actually mean?
That's a great question. So we believe that accepted means that it's been received in the lockbox. So if you, for example, filed a G1145, you may have gotten a text message or an email notifying you that it was received, or perhaps you got the application by certified mail, and so you got a little green notice or some color of a notice telling you that your application has been received by the lockbox. So those are ways to signal that it has been accepted, quote unquote. However, moving forward, thinking through the upcoming October 5th deadline, we encourage you to try to submit your application as soon as possible, to not wait until that date or right before that date to submit, just to be safe, because it is subject to interpretation, right? Some people thought it meant postmarked, but we actually haven't gotten any indication from DHS that that's how they interpret it. So it's best to be safe and submit before October 5th if you are eligible to.
Thank you. And there's a question about what it means when we talk about a clean version of the DREAM Act. So can you elaborate on that?
Of course. So we're demanding a clean version of the DREAM Act because we do not believe that the lives of immigrant youth should be used as bargaining chips for political gain. So there's been a lot of talk in the news about how some legislators, they want to see kind of a trade-off, right? We'll protect DACA recipients, we'll go ahead and pass something like the DREAM Act, but in exchange, we will add resources or funding or implementation of either interior or exterior enforcement. So adding more agents on the border, making E-Verify a lot more mandatory. I mean, these are things that have been circulating as ideas, but we're all steadfast in declaring that we will not take that as an option, that what needs to pass is a clean DREAM Act free of any enforcement.
Yes, and just to share with you all, if you haven't already seen from the NILC's materials, that because NILC has historically worked on challenging enforcement issues, we would definitely not be in support of a bill that furthered enforcement or border militarization, because we don't want some people to be legalized at the expense of their other family members facing deportation. So there's quite a few questions that go into a lot of details, but there's one just quick question about like where you got the statistic, Gabrielle, about the 50% of DACA recipients having employer-sponsored health insurance.
It's over 50%, and I think it's actually 57%. The statistic comes from a survey that was conducted by a professor named Tom Wong in conjunction with NILC and the Center for American Progress, and it's on the Center for American Progress website.
Great, thank you. Can you review again, Gabrielle, how DACA recipients can enroll in the ACA?
DACA recipients cannot enroll in the ACA. They were the only group of lawfully present resident immigrants that were excluded from the ACA.
Okay. And the follow-up question is, but are they able to purchase a plan outside of the marketplace?
Yes, anybody can purchase a plan outside of the marketplace by going to an insurance broker or directly to an insurance company. They just need to do it during open enrollment or when they individually qualify for a special enrollment period.
Okay. And there's at least two questions about travel within the U.S. So, Nasia, is it still safe for people who have DACA to travel within the U.S., including to Hawaii?
That's a good question. I mean, we encourage people to stay on the mainland just to be safe, but if they choose to travel and they have their driver's license or state-issued ID as a form of identification to travel within the U.S., then that should be fine. But just have like a copy of your DACA work permit or your approval notice at hand just in case. But we haven't seen any instances of people getting a hard time traveling within the United States, but just, take precautions just in case.
And for Josh, there's a question, is it worth sharing the DOJ number with workers and asking them to call the DOJ number if their employer is trying to re-verify? Is the DOJ responsive, or is that a waste of time?
Historically, this has been a division of the Department of Justice that is very responsive to workers, and many of the same staff that were there prior to the change in administration remain there. Indeed, when you call the 1-800 number, there's both a free hotline for employers to ask questions, and then there's a free hotline for workers to ask questions and ultimately to register a complaint with the division. If they so choose. The number I've included on the slide is the worker hotline, And the IER, I'm still used to saying OSC, but IER will then, if the employee chooses to make a complaint with the IER section, will engage in sort of a informal mediation process in which they will actually reach out with the worker's consent to the employer and try to ensure that the employer is complying with federal law. And so they will actually follow up with the employer, again with the worker's consent, to try to resolve the situation. And if that doesn't work, and they will take some cases beyond that, again with the worker's consent. And so, yes, we do find that IER is generally a responsive section of the Department of Justice, and they do not share information with other agencies, including DHS or with ICE.
And so there's some questions around continuing to work after a person's work permit has expired. So first, will that get their employer in trouble? And second, what are the consequences to the worker themselves if they continue to work without a work permit?
Yes, in many instances, if your employer, if you continue to work without authorization, so you will continue to work beyond the expiration date of your current work permit, and the employer does not affirmatively ask you to show a new work permit that reflects your ongoing work authorization, then in at least some circumstances, your employer could be found liable for knowingly continuing to employ someone who lacks work authorization. It will be dependent on the underlying facts of your situation, but it could expose the employer to liability since the affirmative legal obligation is on the employer to both verify your identity and work authorization through the I-9 process when you're originally hired, and then if you present a time-limited work permit to your employer, then the employer does have the ongoing obligation under federal law to ensure that you remain work authorized when your current work permit expires. And the I-9 document that you fill out when you're originally hired is the mechanism by which the employer is supposed to do that.
All right. Thank you. And so we will have more time at the end to take more of your questions. And there's many more coming in than we will be able to answer today. So hopefully we'll try to contact some of you afterwards also. But next I'm going to turn it over to my colleague Myra, who's going to talk about our litigation to defend DACA and other actions you can take to support DACA.
Thanks, Shaming, and hi, everyone. So as you may know, last year DACA recipient Martin Batalla Vidal, as well as Make the Road New York, sued to challenge the court order in Texas versus U.S., which had blocked DAPA and the expansion of DACA from going into effect. After President Trump's decision on Tuesday to end the DACA program, both Martin and Make the Road New York asked the court for permission to amend their lawsuit so that they can challenge the administration's actions. This case is both on behalf of Martin Batalla Vidal and Make the Road New York, who, like so many immigrant youth and allies around the country, are fighting to protect the hundreds of thousands of DACA recipients and their families whose lives are being affected by President Trump's cruel and reckless actions. And specifically, we are arguing that Trump's decision to end DACA violates federal law for the following reasons. First, when the government reverses any long-established policy, it must show that there is a good reason for doing so. This is true especially when there has been reliance on a program such as DACA, and the administration's failure to do so violates the Administrative and Procedure Act, which is a federal statute that forbids any arbitrary and capricious actions taken by the federal government, as well as unconstitutional agency decisions and any abrupt changes of direction without adequate justification. We believe that the administration's decision on Tuesday was an abrupt change of policy, which was a devastating decision for hundreds of thousands of individuals who have relied on this program for years. Second, the decision to terminate DACA also violates the Constitution Equal Protection Clause, which prohibits any discrimination on the basis of race, ethnicity, or national origin. The decision to end the program is preceded by a record of racial discrimination directed both against individuals of Mexican origin as well as Latinos. These are the two groups who will bear the overwhelming burden of the program being terminated, as 93% of the DACA recipients are Latino, while 79% are of Mexican origin. The administration's intent to discriminate against these groups has been clear, as from an early days in the campaign, President Trump often called these individuals rapists and criminals, and even last month at a rally in Phoenix referred to these groups as animals. And so we are bringing this lawsuit to demonstrate that this decision violates both the federal laws and constitutional laws because of the reversal in such an abrupt change without a recent explanation, as well as a reversal that's frankly just based on racial discrimination towards these groups. As you may have heard, as of yesterday, 15 states as well as DC have come forward to join the litigation in the Eastern District of New York, and these states have raised similar arguments as those that we're raising in the Batalla Vidal lawsuit. They're also arguing that the Trump administration's decision violated the due process rights of DACA beneficiaries by failing to safeguard personal information that these individuals submitted when applying for DACA. Things are moving rather quickly in this lawsuit. Everything's happening on an expedited manner because of how crucial it is for us to have a decision soon on this program. And we have our first hearing scheduled in New York next Thursday, September 14th. So you can follow our website as well as our Twitter site, and we will keep you updated on the lawsuit. Lastly, I also want to note some changes that have occurred in the Texas versus U.S. litigation. As you may recall, this was a lawsuit that was originally filed to challenge both DAPA and expanded DACA. And through this lawsuit, several states prevented those programs from going into effect. Earlier this year, both Texas Attorney General as well as 9 other states threatened to challenge the legality of the DACA program itself unless President Trump agreed to end the program by September 5th. After Tuesday's announcement, Texas filed to dismiss the lawsuit in the Southern District of Texas. So how can you get involved? Because of everything that's happening and how quickly things are occurring, we do urge everyone to participate by calling their Congress members to request support for immigrant youth and the DREAM Act. Specifically, we'd urge you to call your targeted Congress people. These individuals can be found at the weareheretostay.org/call list. And we also urge you to tweet at congressional members through the link provided at weareheretostay.org. You can also set up meetings with your Congress members. Oftentimes, they will be most receptive to people who live within their districts, but they will also be open to anyone else who is willing to go and talk to them in person. Additionally, there have also been rallies and marches since the Tuesday announcement, and we encourage you to participate in those actions. And you can visit www.defenddaca.com for info and resources and to find more events in your area. You can also use the weareheretostay.org to attend an event near you. Third, you can also share your story by going to the link on this website. And lastly, we are also encouraging you to create petitions using Define America's template that is provided through this link. Define America's template can be used to create your own petition so that it is targeted and can be more personal. Many college students have created petitions for their campus and are gathering signatures through this form.
All right, thank you. So we hope that all of you will take a couple of those steps to really show your support for people who have DACA and for other immigrant youth. We've listed a couple of resources for you. One of them Josh mentioned in his section, which is a document we created with United We Dream and Advancing Justice Asian Law Caucus to talk about employment issues. We have an FAQ around what the DACA termination means. We have the top 5 things that you need to know about the ending of DACA, which is a document we created with United We Dream. And we also have a side-by-side comparison of all the different legislation that's been introduced this year, which includes the DREAM Act, but also Bridge and RAC, which all seek to provide some type of protection or extension of stay for people who qualify for DACA. So we're going to turn back to answering more of your questions. First one, we'll go to Ignacia. Do you have suggestions for DACA recipients whose work permit expires after the March 5th cutoff date?
That's a good question. So generally, based on the information the Department of Homeland Security provided, it's our understanding that if you submit your application, it's going to get rejected if your expiration date is March 6th or later in the year. Some people are deciding to move forward in the hopes that maybe they'll accept their application, make some kind of an exception, maybe just worst case scenario, just reject the application but not process the fee. But we don't really feel as confident that will actually work out. So it's best if you're in that situation to start thinking through, like, is there any other type of immigration relief that you qualify for? Have a consultation with an attorney or a BIA accredited representative. Start to look at every aspect of your life. So your ability to have health care, your ability to stay in school, your ability to work, and see what's the plan A, B, and C. Because maybe by the time that your DACA expires, we'll have some kind of legislative remedy. You'll be able to still have a work permit, maybe through the DREAM Act or through another process. But you still want to plan for the possible what if. What if it expires and you revert back to being completely undocumented? So just plan ahead, think through how not having DACA could affect each aspect of your life.
And if somebody's work permit has already expired before September 5th, can they still apply for renewal?
Their work permit expired before September 5th? Mm-hmm. According to the DHS guidelines, unfortunately, no, your expiration date has to be between September 5th and March 5th. And if that's the case for you, then you can apply and have to submit your application before October 5th. But if your work permit already expired by the time of the announcement, unfortunately, you cannot apply for renewal.
All right. So there's some more questions also about employers and workplaces. How would you assess the level of risk for businesses that knowingly continue to employ staff whose DACA expires?
I mean, that's hard to say. We don't have a lot of information from DHS or ICE. In fact, we have very little as to how they target employers or select employers for what's called an I-9 audit. And that would be the mechanism by which ICE would potentially identify that an employer has knowingly hired or continued to employ a worker who lacks work authorization. We do know that that ICE has prioritized for I-9 audits or I-9 scrutiny employers or the employment sector that touches on national security or critical infrastructure. So they have publicly said that that is a priority. So I think in those employment sectors, there might be a higher potential for an employer to face an I-9 audit. But in reality, I believe, although this I would have to double check our FAQs, I believe last year ICE engaged in roughly 1,200 I-9 audits. I'll have to verify that, but overall, the number of I-9 audits that ICE engages in compared to the total number of employers in the U.S. is relatively small. So again, we don't, we don't really have any clarity from ICE as to how they select employers, but we do know that the overall number of audits that they engage in on an annual basis is quite small compared to the total number of employers.
And Gabrielle, do you want to address really quickly some other options or alternatives to employment that people have had thought in the past, such as forming their own?
Sure. So as Josh mentioned earlier, there is no I-9 or employment authorization verification process associated with self-employment. So people can work individually as independent contractors. They can either do that without setting up a business entity, in which case they would be considered a sole proprietor. That would give them no protection from liability, so that their personal assets would be at risk for anything that was associated with the business. Another alternative that some people have done is gotten together with others and formed a worker-owned cooperative. And that can be done either on an informal basis or by setting up a legal entity called a limited liability company. So a limited liability company would be a group of worker owners who came together, set up a business entity, and then use that business entity to contract with clients who ultimately did jobs. Educators for Fair Consideration has a guide that I believe is called the Entrepreneurship Guide that discusses these alternatives.
Thank you. And Myra, can you clarify when you said that the case, there's a motion to dismiss the US v. Texas case, what does it mean to actually dismiss the case?
Sure. So in the U.S. versus Texas case, essentially what Texas has requested is for the court to dismiss or release the lawsuit. This would be done without causing any prejudice to any of the parties. So essentially it wouldn't create any, it wouldn't allow the judge an opportunity to continue viewing the claims in that case or to continue reviewing the lawsuit and issue any decisions on it. So it's basically the Texas requesting for the judge to stop having oversight over that case and for that case to no longer be in the court's holding.
And there's a couple of questions around whether people who lose their DACA status will be targeted for deportation, which I'll try to answer. We've already seen some DACA recipients being put into the removal process now. For instance, if they have a criminal conviction that would disqualify them from DACA, but they got that conviction after they last renewed their DACA, or for instance, if there's some kind of gang allegation. So there are some instances when even people who have DACA right now are getting picked up and targeted by ICE. But in general, if somebody has qualified for DACA, that means that they've been in the U.S. for a period of time and have a lot of favorable factors in their lives. And we know that ICE is continuing to focus mostly on people with criminal convictions or other people that they claim are threats to public safety. So if people lose their DACA, there's no guarantee that anybody would be completely safe, but we do recommend that people really know their rights and know what to say if they're stopped by ICE or they encounter Customs and Border Protection officers, and also that people get consultations with attorneys or accredited representatives, because we found that many DACA recipients actually qualify for another way to remain in the U.S. So those are two things that people can do now to try to prepare for the time when they might revert back to being undocumented. So there's some questions too. I don't know if any of you can take this, but people have questions around the legislative process, how often they should be calling Congress and when they should be doing that.
Crickets.
Yeah. I mean, we really urge you to call Congress now, because the window of opportunity to really push for the DREAM Act is best right now, while DACA's at the top of the news, and at this time when everybody's really talking about it, this is probably the best time to really push for it. So don't delay, make your calls today and get all your friends and family members to make calls too.
And I would just plug the website weareheretostay.org as a place where you can find information about activities that are happening in your locality in support of DACA, such as local rallies and things like that.
There's a question about what can states or state elected officials do to help DACA recipients? And one thing that many states can do connected to these issues is to pass legislation that provides health care for all, right, Gabrielle?
Yes. Or another thing, that there are states that provide in-state tuition to students who are residents, regardless of their immigration status. There are states that allow DACA recipients to get in-state tuition, but not all immigrants. So that legislation would need to be modified. Another thing would be to provide driver's licenses to everyone, regardless of status. There are also some immigrant-friendly policies related to refusing to respond to ICE requests that people be held in detention. And Shimeng, you can speak to this better than me.
Yeah, and for instance, in California, there's been efforts to have California actually fund legal services for immigrants and also fund legal services for people facing deportation. There's been state bills to really limit the impact of deportations by prohibiting local law enforcement from collaborating with ICE. So there's definitely a lot of things that you can try to push your local and state elected officials to do. That could also include a local sanctuary policy that doesn't allow local law enforcement to ask people about their status, and also makes it harder basically for ICE to go about their business. So going back to workplace issues, Josh, people wanted to know what would actually happen to a DACA recipient once they lose their work permit and they continue to work. What would be the consequences?
Continuing to work for the same employer, essentially then the person would be engaged in working without authorization, which in and of itself is not a crime under federal law. It is a crime to make false statements about your work authorization status or your eligibility for employment, to use someone else's identity information in order to keep working, or to provide any false documents to show that you are work authorized. So if your employer, for example, comes to you because your work permit is expiring, and you present a fake work permit, that could expose you to criminal liability, since that is unlawful. But if your employer fails to check whether you remain work authorized, and you simply continue to work for the same employer after your work permit expires without making any false statements or providing false documents or using anyone else's identity information, then you should not be exposed to any criminal liability. In some circumstances, and this would really depend on your underlying situation, working without authorization can adversely impact your ability to adjust your immigration status down the road if you later have a basis to do so. But we don't think there are any additional immigration consequences beyond those that you may already be subject to on account of your unlawful presence in the U.S. after your DACA and work permit expire. Ideally, though, you should consult a qualified immigration attorney or BIA accredited rep to assess any risks that are specific to your situation.
Thank you. And we know the reason that a lot of people have been delayed in filing their renewals is because of the fees. So do you want to share some tips, Gabrielle, around the renewal fees?
Sure. You're probably aware that a lot of people have set up GoFundMes and are developing funds to help to make grants to people to pay for their renewal fees. But if it becomes necessary for you to borrow money for your renewal fee, please don't go to a payday lender. They charge exorbitant rates. Look for a community development financial institution or a credit union that can lend you the money at an affordable rate. One way to find them is by going to the website of the National Association of Latino Community Asset Builders, nalcab.org, and look at their members. A number of their members have programs that are specifically for the purpose of helping people afford their DACA fees.
And the last question is for any of you. What happens to a person's Social Security number? So they receive that because they had a valid work permit. So after the work permit expires, in what circumstances can they still use their Social Security number?
So your Social Security number, once it's assigned to you by the Social Security Administration, remains your unique Social Security number for the rest of your life. So it is still a valid Social Security number for you to use. It is not valid by itself for work purposes. So you would still need a valid work permit in order to be working with authorization, but you can continue to use your Social Security number after your work permit expires for other purposes, such as filing in any required income tax returns, which is important or can be important down the road if you do then later have a basis for immigration relief. It can be important to show that you've complied with tax laws and filed any required tax returns while you are in the U.S. And you can also use it for other purposes, such as opening a bank account. So it remains your number going forward, but in order to use it to show work authorization, you would also have to have a valid work permit accompanying your SSN or your Social Security number.
Anything you want to add? For instance, what about using it for credit cards in the future, loan applications?
I mean, it should be valid. It should be valid for those purposes.
All right. So we're almost at the hour, so we want to thank you all for attending, and you will definitely receive a copy of the PowerPoint and a link to the recording tomorrow. You'll also receive a short 3-question survey about this webinar, which we hope that you complete so that we can get feedback and continue to improve our webinars. And we know this is a really difficult time for many people and for the movement at large. So we hope that all of you really stay strong and stay connected and really get involved if you are not already involved, because we know DACA was something that was really won through organizing led by immigrant youth. And so together we can do everything we can to make sure that we protect as many people in the immigrant community as possible. So thank you again.